الجامعة الإفتراضية السورية Criminal Law by عماد الدين محمد. الوحدة التعليمية الأولى Chapter 1. يغطي هذا التسجيل السلايدات من 1 وحتى 23 Slides from 1 to 23. تقدمت مبادرة ضوء بصوت دانة بيرقدار. Slide number 1. Introduction to English Criminal Law by عماد الدين محمد. Slide number 2. للاطلاع. Acknowledgement. The audio recordings that accompany the PowerPoint presentation called An Introduction to Criminal Law have been made and kindly presented to the law students of the Syrian Virtual University by Ms. Julie Elizabeth Boyd. Ms. Julie Elizabeth Boyd has both an LLB Bachelor of Laws and LLM Master of Laws from the Manchester Law School of Manchester Metropolitan University in Manchester, England. In addition, we would also like to give thanks and acknowledgement to Mr. Haytham Elmir Mustafa, the IT engineer, for his much appreciated technical support and presentation for the PowerPoint slides for this presentation called An Introduction to Criminal Law. Slide number 3. What is a crime? A crime is a conduct which the law deems to be criminal under statute, which means an act of parliament, or common law, which means case law. This conduct is prohibited because it involves the threatening or causing harm to individuals or to the public interests. Conduct may be deemed to be criminal due to moral and/or social reasons. A crime may be committed against a specific person, but it is still classed as a public wrong as it affects the public at large by making society feel less secure and safe from harm. Slide number 4. للاطلاع. Distinguishing criminal law, the law of tort, and contract law. Criminal law, the law of tort, and the law of contract are areas of law which can overlap. Criminal law is a branch of public law as it affects society at large. Tort law and contract law are branches of private law as they affect individuals. Different terminology is used in criminal proceedings and civil proceedings. Slide number 5. للاطلاع. Distinguishing criminal law, the law of tort, and contract law. Example. In criminal proceedings, a prosecution is brought by the state, which means crown, and in tort and contract law, an individual sues another individual or an organization. In criminal law, the state prosecutes a defendant. In tort and contract law, an individual sues another individual. Criminal law is concerned with the prosecution of individuals whose behavior or conduct has not met the standards of acceptable behavior expected of citizens. These individuals have committed a public wrong. Tort and contract law govern the law relating to private wrongs. Slide number 6. للاطلاع. Distinguishing criminal law, the law of tort, and contract law. In criminal proceedings, a verdict is delivered at the end of the trial, according to which the defendant will be found guilty or not guilty. Criminal law is concerned with the punishment of offenders, and a defendant who has been found guilty or convicted of a criminal offense will be sentenced. Sentences include terms of imprisonment to community sentences such as a community punishment orders and community rehabilitation orders and fines. A defendant who is found not guilty has been acquitted. At the conclusion of a civil trial, there will be a finding that the defendant was either liable or not liable. Civil law is concerned with compensating the wronged individual through the payment of damages. Slide number 7. The function of a criminal law. Criminal law has the following functions. The law sets standards of behavior which citizens must meet, and these standards reflect the values of society, such as morality or religion. A criminal law prohibits conduct which threatens or causes harm to individuals or to the wider public. The criminal justice system is punitive, punishing defendants for criminal conduct. Another argument in favor of criminalizing certain conduct is that of deterrence. It is argued that if certain behavior is deemed to be criminal, then members of society will refrain from such conduct. By punishing offenders, the criminal justice system seeks to encourage other members of society to comply with the law. Slide number 8. Sources of criminal law, statute, and common law. Some criminal offenses have been created over time by case law. These offenses are called common law offenses. Murder and manslaughter are common law offenses. These offenses have been defined by judges in previous cases, and the current definitions of these offenses are still found in case law. Other offenses are established in statute, which means acts of parliament, and are called statutory offenses. These include theft, rape, and wounding or causing a grievous bodily harm with intent. The definitions of these offenses are found in statute, although the elements of such offenses may be further defined by law. Sometimes offenses are charged contrary to statute, but the definition of the offense is found in common law. Examples include assault and battery. Slide number 9. Sources of criminal law, a criminal code. Some countries have a criminal code, which is a comprehensive document establishing the definitions for all criminal offenses and defenses. For many years, the Law Commission has given consideration to the adoption of such a criminal code in England and Wales. In 1989, the Law Commission proposed a draft criminal code, but the UK government has yet to adopt such a code. The advantages of having a criminal code are: the law would be more accessible, there would be clear definitions for all offenses and defenses, it would avoid any ambiguity which can arise under the common law. Key advantage of the common law is that it changes as attitudes in society do, so it can evolve accordingly. Slide number 10. Sources of criminal law, a criminal code. The one disadvantage with a criminal code would be its inflexibility. For example, in 1991, the common law deemed rape by a husband of his wife to be a criminal offense. However, now such changes can be made relatively quickly, as the judiciary can define or clarify key elements of our criminal offenses. Therefore, a criminal code would be less flexible, as such alterations to the law would have to go through a long administrative procedure before taking effect. Slide number 11. The classification of offenses. Offenses are classified by their seriousness, and there are 3 categories of offenses. 1. Indictable only offenses. 2. Either way offenses. 3. Summary only offenses. Slide number 12. Indictable offenses. These are the most serious offenses, including murder, manslaughter, rape, robbery, and wounding or causing a grievous bodily harm with intent, and they all carry high penalties with a maximum sentence of life imprisonment. All of these offenses must always be tried in the Crown Court with a jury. Slide 13. Either way offenses. These are classed as medium serious offenses. The facts of the particular incident will determine the severity of the offense. They include theft, assault, occasioning actual bodily harm, wounding or inflicting grievous bodily harm, burglary. The defendant can be tried in the Crown Court with a jury or in the Magistrates' Court without a jury. Slide 14. Either way offenses. A model of a trial hearing will take place in the Magistrates' Court to decide where the defendant will be tried. If the magistrates consider the offense to be too serious for the Magistrates' Court, they will commit or send the defendant to the Crown Court for trial. The defendant cannot choose. If the magistrate's court consider the case suitable for summary trial, they will accept jurisdiction over the case. The defendant can choose to be tried in the magistrate's court, or he or she can choose to be tried in the Crown Court by a jury. This is called the right to trial by jury. A right to trial by jury is not always available, and the defendant has no right if he or she is charged with a summary-only offense. Slide 15. Summary offenses. These are the least serious offenses and include driving offenses, assault, and battery. They carry lighter penalties, which can be from endorsement points on a driving license, a fine, or a short term of imprisonment. Summary offenses are tried in the magistrate's court without a jury. A defendant charged with a summary offense has no choice or right to a trial by jury. Slide number 16. للإطلاع, the classification of offenses, depending on the level of seriousness, from the least serious to the most serious. Number 1. Summary-only offenses. Example, driving offenses, assault. Penalties, endorsement points on a driving license, fine, community service, short-term imprisonment. Trial, magistrate's court without a jury. Number 2. Either way offenses. Examples, theft, assault occasioning actual bodily harm, wounding or inflicting a grievous bodily harm, burglary. Penalties, ranges. Trial, either Crown Court without a jury or Magistrate's Court without a jury. Number 3. Indictable only. For example, murder, rape, robbery, wounding or causing a grievous bodily harm with intent. Penalties, high penalties upon conviction, maximum sentence of life imprisonment. Trial must always be tried in the Crown Court with a jury. Slide number 17. The criminal justice process. It is important to understand the criminal procedure and the process by which a case proceeds through the criminal justice system. When a criminal offense happens, it is usual practice for the police to investigate the alleged offense and for the state to prosecute the alleged offender. It is a rare possibility for an individual to bring a private prosecution in criminal law. Example, a person takes your mobile phone out of your bag without your knowledge and keeps it. You would make a telephone call to the police to report the offense. Once the offense is reported, the criminal process begins. Slide 18. للإطلاع, the criminal justice process. مخطط كالتالي. Number 1. Investigation. Number 2. Arrest and charge. Number 3. First court appearance. Number 4. The trial. Number 5. The verdict and sentencing. Slide 19. Investigation. The police would investigate the offense and take a witness statement from you and from any other witness who may have been present when the offense happened. They would also seize any closed-circuit television (CCTV) footage which may have been available at the time, and they would try to find the offender. Slide 20. Arrest and charge. Example, an investigating police officer finds a person who he believes is the offender, the suspect. He arrests the person for the criminal offense of theft and interviews him at the police station. It is important to know that there is a legal guidance for the treatment of arrested persons and various other procedures at the police station. Slide 21. Arrest and charge. The police officer may you to attend an identification parade at the police station so that you can try to see the offender. If there is enough evidence, the police officer would then consult the state and charge the suspect with the offense of theft and send the case papers to the state. The state is the authority responsible for the decision to bring a criminal prosecution against a person. If the state decides not to prosecute the suspect, who is now called the accused, it will not proceed with the case. An option for you would be to privately prosecute the accused. The major disadvantages of a private prosecution are that you would bear all the costs. You would have limited access to scientific resources and expert witnesses, which will also cost money. So the majority of criminal prosecutions are brought by the state. Slide 22. First court appearance. The next stage in the criminal process is the first court appearance. The accused or defendant appears at court as soon as possible after he or she has been charged with the offense. The case would be called R v. defendant or Regina v. defendant. The R or Regina refers to the Queen, the state, who brings the case against the defendant. Slide 23. First court appearance. The first court appearance is at a local magistrate's court. At this hearing, the charge would be read to the defendant and he or she would be required to confirm the personal details, which means name, date of birth, address. The date for the next court hearing will be stated. After a number of pre-trial hearings, which depend upon the offense charged, the case will be given a date for trial. The trial will be held at either the magistrate's court or at the Crown Court. The court at which the trial is held will depend upon the classification of the offense with which a defendant is charged. In the example, the defendant is charged with the offense of theft, which is an either-way offense. Mode of trial proceedings will take place to determine whether the defendant will be tried in the magistrate's court or the Crown Court. نهاية التسجيل من شريحة رقم 1 وحتى 23.